Division is now in session. The Honorable Judge Shirley M. Kawamura presiding.
On case number 1CCD-21-683, Sarah James versus Dr. Patrick J. O'Donnell, MD, on plaintiff Sarah James' motion for declaratory judgment, in the alternative, motion for judgment on the pleadings. Appearances, please.
Sarah James, plaintiff.
Good afternoon.
Good afternoon.
And good afternoon, Your Honor. Anderson Meyer on behalf of defendants Dr. O'Donnell, Dr. Tan, and Kapilani Medical Specialists.
Good afternoon.
Good afternoon, Your Honor. David Grubner appearing on behalf of Nurse Takinaka, Kapilani Medical Center for Women and Children, and Hawaii Pacific Health.
Good afternoon.
Good afternoon, Your Honor. Colette Erica on behalf of Dr. Selena Peters.
Good afternoon. Parties prepared to proceed?
Yes, Your Honor.
You can have a seat. From the move on? I'm sorry. From the move on? You can stand. I'll hear from you first.
Oh, okay. Plaintiff is here on motion for declaratory judgment and judgment on the pleadings. And the authorities are in my motions. Would you like a summary or something?
This is your chance to provide me with any argument you wish. If you want to rest on your moving papers, that's fine too. It's up to you, sir.
I'll rest on my moving papers.
Okay. And you will have a chance to reply. Okay.
Okay.
You can have a seat. All right. Who would like to go first?
If I may, Your Honor?
Sure.
Thank you. I think the position from my clients, Dr. O'Donnell, Dr. Tan, and Kapilani Medical Specialists are in our opposition memorandum. But I think what it really comes down to, Your Honor, if this is neither a motion to strike nor a motion for summary judgment, and it really is a motion seeking declaratory judgment, that's not appropriate in this case. There's been no request for declaratory judgment pled in the First Amendment complaint. That's not something that can be raised by motion. And on its own, that enough warrants denial of this motion. If the court is inclined to consider it as a motion to strike, any of the responses in my client's response to the First Amendment complaint, I believe we've addressed the bases to deny such a motion to strike in our briefing. The responses to the voluminous paragraphs of the complaint were appropriate. They were denied where possible. They were partially admitted where possible. And they also do reference the medical records, which speak for themselves. That is a common practice in these sorts of cases and is by no means a violation of any of the rules of civil procedure. Unless the court has any further questions.
I do not.
Thank you.
Thank you.
Thank you, Your Honor. Likewise, we would, I guess, stand on the pleadings as well. I think in the reply memorandum there was an admission that this is we actually covered the basis that it might be construed as a motion to strike or as a motion for summary judgment, and now plaintiff has basically admitted that those are not being sought here at this time. So we'll take them at their word for that. So to the extent it is summary judgment or motion for judgment on the pleadings and or for declaratory relief, we have the same arguments as Mr. Meyer. We join in those and stand on our pleadings for that. Thank you.
Your Honor, on behalf of Dr. Peters, we join in our co-defendant's motion.
Okay. Your reply?
Yes, Your Honor. If the declaratory judgment and judgment on the pleadings aren't granted, I would just move forward with their answers being admitted. But I stand on the pleading on the motions that I submitted.
All right. With respect to plaintiff's motion for declaratory judgment in the alternative motion for judgment on the pleadings, the court does find, first of all, I'm going to address the motion for declaratory judgment. In the instant case, the court finds that plaintiff has filed his amended complaint. It does not seek declaratory relief first of all. Second of all, HRS 632-1 provides relief by declaratory judgment may be granted in civil cases where an actual controversy exists between contending parties. Yet, the court did review each of plaintiff's claims, and they reveal allegations arising from actions already committed in the past. In that no actual controversy currently exists, pursuant to 632-1, the court finds that declaratory relief is not appropriate. Third, defendants have answered denying, not admitting certain allegations as plaintiff's claims. Fourth, to the extent that plaintiff's request may be couched, although it is true in his reply, he's saying that it's not. But I did also try to view it as a motion to strike. If that is the case, then the motion to strike is untimely, unsubstantiated. Fifth, defendant's answers the court finds are sufficient under HRCP Rule 8. And finally, the court does find that this is a medical negligence action and not appropriate for decision in a declaratory judgment action. Or a claim based on negligent or intentional acts is not appropriate for decision in a declaratory judgment action. Therefore, plaintiff has failed to establish at this early stage in the proceedings a legal basis and facts sufficient to establish any relief or declaratory relief, and the request for declaratory judgment is therefore denied. Now, moving to judgment on the pleadings, HRCP Rule 12C. A motion based on 12C serves much the same purpose as 12B6 motion. It's a motion to dismiss for failure to state a claim upon which relief can be granted, except that it is made after the pleadings are closed. A 12C motion for judgment on the pleadings only has utility when all material allegations of fact are admitted in the pleadings and only questions of law remain. In a motion for judgment on the pleadings under 12C, the move-on must clearly establish that no material issue of fact remains to be resolved and that he is entitled to judgment as a matter of law. The circuit court is required to view the facts presented in the pleadings and the inferences to be drawn therefrom in the light most favorable, of course, to the non-moving party. In the instant case, plaintiff claims that defendants have admitted to a majority of the allegations as set forth in the amended complaint, which, having reviewed the answers submitted, and if this is not a motion to strike, it's simply not true. Plaintiff has not met his burden under HRCP Rule 12C. Now, even converting this motion to a Rule 56 motion for a summary judgment, the court finds that plaintiff fails to present any legal basis for relief under Rule 56 and fails to provide any admissible, properly authenticated evidence in support of the motion. He has not argued, much less established, that there would be no competent evidence to support a judgment against the defendants. Based on Ralston and 56F, it is further clear that summary judgment should not be granted when there is still time for, and indeed in this case where discovery has not even begun. Therefore, if this is considered a motion for summary judgment, that request is denied. Finally, plaintiff's request for Rule 11 sanctions is procedurally defective in violation of HRCP Rule 11C and substantively meritless. A fundamental tenet, though, of Hawaii law is that pleadings prepared by pro se litigants should be interpreted liberally, and courts have extended this liberality doctrine to include pro se motions. Even given this liberal standard, plaintiff has set forth insufficient legal and factual basis for granting of the motion, and therefore the motion is hereby denied in its entirety. All right. Who would like to prepare the order? Anderson?
Happy to, Your Honor.
All right. Mr. Meyer to prepare the order. Court stands in recess.
Thank you, Your Honor.